Very much.
Thank you. Thank you.
We will now have updates on Title IX regulations, and this is Mrs. Johnson and Attorney Kapocious.
Good job.
Oh, yay.
Good evening.
Good evening.
Excuse me. So as shared in your staff report, in April of this year, the Department of Education issued its final Title IX rules that apply to complaints of sexual discrimination occurring on or after August 1st. So some of the key changes aimed at enhancing protection and clarifying processes was the definition of sex, including discrimination on the basis of sex stereotypes, sex characteristics, pregnancy or related conditions, sexual orientation, and gender identity. Revised standard of harassment. Training, as shared, training needs to continue in the regulations of 2020, and we also need to train on the new regulations. The reason for that is those complaints that happened before August 1st, we need to follow the previous regulations, and then those happening August 1st or beyond, we would follow the new regulations. Complaints formerly needed to be in writing. They need to be written, and now they can be orally given as a complaint. There's a broader scope. It covers conduct that impacts our programs and activities, no matter where it happens. And then some of the efficiencies that I'd like to note are the expansion of our informal resolution options. Formerly, if they weren't available, we didn't need to offer them, and now we need to always offer them. The only time that we wouldn't is if the complaint or the grievance is an employee and student complaint. It emphasizes the prompt and equitable handling of grievances with a focus on minimizing delays at each stage of the process. And then the investigation process, the removal of sending each party, or this is really an efficiency we're looking forward to. Previously, we had to give each, the complainant, the respondent, an opportunity to review our findings and give them 10 days to respond. This has been removed, so it really shortens the timeline of these grievances and the processes. And now I'll turn it over to Mark to discuss the number of states and organizations who have challenged the implementation of these final rules.
Yeah, thank you. There's, these final rules were implemented, or I should say they came out in April. Okay, shortly thereafter, there's been a number of states that have litigated this matter. There's currently 26 states that are not subject to the new, or I should say the final rules as set forth in April. In addition to that, there is a case in Kansas where a federal judge has identified what are referred to as plaintiff organizations, and there's 3 of them: Moms for Liberty, I think the Young American Foundation, and Female Athletes United. Okay, so those are considered plaintiff organizations. And to the extent that any members of those plaintiff organizations have standing in a school outside of the area upon which this judge has jurisdiction, those schools are prohibited from enforcing the new final rules set forth. Okay, and that includes schools within the Oshkosh area school district. Okay, not all, but some. Okay, and so that obviously in Oshkosh is no different than a lot of other school districts throughout the country, addressing this kind of conflict of the law. What makes Wisconsin slightly different is that one of the biggest issues as it relates to the Kansas decision was what Sabrina mentioned earlier, which is the expanded definition of sex-based harassment. Okay, that obviously was one of the biggest issues that was set forth. However, in the 7th Circuit, of which Wisconsin, Illinois, and Indiana are members of the 7th Circuit, we have a case out of Kenosha, the Whitaker versus Kenosha Unified, which interpreted Title IX to include sex-based harassment that affected a child that was transgender. Okay, so the reality is we still are operating under that definition based on the Whitaker decision regardless of how the Kansas injunction applies to those schools. Now, what that Kansas injunction means for Oshkosh is that for the schools that have a member within the plaintiff organization, they would essentially be operating under the pre-August 1st Title IX rules. Now, the benefit is that Oshkosh has both the pre-August 1 rules as well as the post-August 1 rules. So depending on the school that a child is at would depend on how the policy is applied or which policy would be applied. So it's complicated, okay?
Yeah.
But I would say the good news is that you have an existing policy. That policy remains in effect, subject to, without the benefits perhaps of the efficiencies set forth.
I'll start with one of my questions. Under number 5E, it's the broader scope where this covers conduct that impacts OASD programs and activities regardless of if it occurs outside the United States or outside of our educational program or activity. How does that work with social media? How can, we just got rid of 20 teachers. Who's going to do this work? It would seem to me that we're going to have to, maybe there won't be that many, but how do we fit that into our schedule to be looking at social media, Facebook, he said, she said? I would think that would be a lot.
Well, one, there would have to be a complaint that you're
Right.
following up on.
Right, right.
And the complaint doesn't necessarily have to be generated by a quote-unquote complainant. As the expanded rules permit, it could be filed by another person. But there's no affirmative duty to go out there and search for it. Right?
Absolutely.
So, I guess that would be the response. That
Okay.
you treat it no differently than you would any other complaint or become aware of a circumstance.
So we do have 2 coordinators here in the district, so those complaints would come primarily to myself. And then we also have Matt Kamer, who is our second coordinator. We don't know what the scope of the complaints that will come in.
Right.
But as we have them, if they are coming in a lot faster, there's more work to be done, we'd have to have the conversation of if we are manned to be able to work through all of the complaints.
That's one of my concerns. Mrs. Carlin?
Are we at risk of losing federal funding, and if so, how much, and what is that process?
Well, that's a big question, and I'll start by saying the Oshkosh Area School District is a recipient of federal financial assistance. Now, to what extent you receive federal aid, it's going to be found in the form of special ed, it's going to be found in the form of food service, various grants and the like. I'm going to just kind of guess it's some percentage of your, 10 to 20%. But so obviously, as a recipient, you have to follow certain guidelines. It's part of a grant contract. As it relates to Title IX, okay, you currently have a Title IX policy in place, and the question is, I believe, if you did not act on the new rules, would that jeopardize your funding? Is that the question? And I think the answer to that is it's unlikely. And the reason I say that is because, one, there would have to be a complaint, an investigation, and then ultimately what's called the OCR, Office of Civil Rights, would issue a corrective order or corrective action plan to the district. And the reality is that'll take a long time, okay? To our knowledge, we've done some research on this, there's been no other agency recipient in this case that has not received federal financial assistance.
Okay.
But I would tell you that it's obviously theoretical.
There has been a number that's been floating around. Where is that number coming from? So I think it was 6 million or something.
What number are you referring to?
The potential funding loss that we had. We
Yeah,
could have.
I would defer to business office to see what our
Okay.
financial, what federal funds are received annually.
Okay.
Yeah. Drew, do you have that number by chance? The special ed funding?
Everything all in would be about 8% of our revenue. The title funds, the number we had calculated when it was just looking at like the title grants that we sign assurances for is in the neighborhood of 5.5 million. But when you include everything within the federal government, it's about 7 to 8% of our revenue.
Okay, thank you.
Mrs. Malik.
I guess it's a multi-layered question. One, are we in compliance with federal law and federal regulation right now as it stands in Wisconsin? And then two, does anyone in this district, when we are seeking Title IX funds in the future, have to assert that we are in compliance? And would that further jeopardize? And then final part of the question is, what other liabilities are we open to if we do not adopt these new policies?
Well, as I mentioned, I'll start with the last one, which is to say, I believe that by virtue of us being within the Seventh Circuit Court of Appeals, that many of the issues that were set forth in the complaint in Kansas are largely already been spoken for. Okay, so and then related to that, I believe the second question, going back in time here, was what other liabilities would you have? So I think that effectively responds to that liability, which is to say if there's a complaint for a sex-based harassment, the district would investigate and would conduct the appropriate process. So there would be no liability from that perspective. The only liability potentially would be, as we mentioned before, the expanded, location essentially, that Title IX violations might occur. So, for example, if there was a school trip and it happened to be outside of the United States, and there was a claim of sexual discrimination, under the older rules, okay, there wouldn't be jurisdiction. Now there would be. Okay, so that would potentially be an issue that would come forward. And again, to our knowledge, there's been no recipient of federal financial assistance that has been cut off as a result of not adopting new regulations at this particular time.
Is there an affirmative requirement, though, that a staff member or someone who is filing these applications state that we have policies in place that are in compliance with current final rules under Title IX?
Yes. Yeah.
So someone will have to assert that. Would our district be able to do that if we are not in compliance, if we do not have these new policies in place?
Yeah, I think the answer is there is a policy in place. It's just not adopting the new final rules, right?
Right, so would we be able to assert that we have adopted the new final rule and therefore are entitled to aid if we have not passed the policies that reflect the new final rule?
I would say this, the policies are sufficiently in flux nationally to the point where the majority of the states in the country are not subject to the new final rules, that I'm not taking a position here. I'm just telling you what we believe, and we've talked about this at the firm for extensively. Again, the likelihood of having federal funds withdrawn is small.
Right, but that's still not answering the question of would someone be able to assert that we are in compliance with these final rules and have policies in place if they have not been adopted? Because someone has to press the button saying,
Right.
yes, we are in compliance. How could we actually assert that as a district?
Yeah, I don't believe that technically the district is in compliance if you have not adopted the final rules.
And that would be one of our concerns moving
Yeah.
forward, without the adoption of it.
Yeah. And I guess when I've talked to other boards and other administrators about this similar issue, again, I don't see a tremendous risk for boards to adopt the new final rules, because again, this will likely be resolved at the Supreme Court level. Okay, and it may be resolved before the end of this calendar year. At this pace, I mean, there's already been 2 circuits that have chosen to not overturn an injunction. Okay, so we have kind of momentum trending towards a Supreme Court decision. Okay, so for that reason, in addition to the fact that the new regulations, the new rules, provides for some greater flexibility for schools and for Title I coordinators to reach a more prompt, or in which cases, an informal resolution. So I don't necessarily believe that the new regulations are problematic at all from the procedural perspective. And then from the substantive side, which is to say the definitional parts, A of all, we're under the Court of Appeals, Seventh Circuit Court of Appeals rule. And secondly, it's likely going to be resolved at a body, at the Supreme Court level.
Maybe. Right? Because no one knows what cases the Supreme Court is going to take or isn't going to take. And we have separate rulings, all over the country with different interest groups lobbying for different interests and different courts making different decisions based on, let's just be real, probably political leaning feelings. What matters to me most, and has always mattered to me, is that we're protecting and safeguarding all kids. Title IX's done a lot of really good things. I have daughters that play sports, and they likely wouldn't be able to do that without Title IX to the degree that they've been able to. So I guess what I'm kind of hearing is there's a lot in flux, a lot of different court cases going on. But as a board member, I'm going to vote, if this ever comes up again, and I don't know, but to make sure that all kids are being protected in our schools. And yes, there's some, like E, when I read that over the broader scope, there's some vague areas there too. But the way I interpreted it, right, if OASD's hosting something, or if a kid's going on a field trip somewhere, right, we want those kids to be safe whenever they're within our care, I would think, wherever they're in our care. I mean, if my kid was doing something that they weren't supposed to be doing to another child, I would, or had something happen to them that shouldn't have happened to them, I would want to make sure that we were able to address that. So thanks for all the questions. I don't know if anyone else has any more, but those are my thoughts.
Kelly, do you have a question? Barb?
Barb first. Thank you. So under, in your staff report, under 3 key communications, letter E, I just have a couple of questions that I'm wondering about. About in the middle of that paragraph, you note that another list was published on July 26th, including 3 Oshkosh schools that are attended by minor children of Moms for Liberty members. We've had some history in the district of a group, I believe they're called Winnebago County Moms for Liberty, who would challenge some of our classroom and or library materials. Our policy on challenging materials limits those challenges to people who either live in the district or have children attending the district. So my wondering is, based on what you've written here, how do we know that there are minor children of Moms for Liberty who attend those schools?
That's a good question, because this obviously, there's thousands of schools that are affected. And I believe the judge has taken the position that they're minors and they're not going to be disclosing their names. So the judge has independently verified this information.
And where we've taken the information from as the court case, like in Kansas, as they would public update lists.
Okay.
So that's what we're verifying from those lists. So that's why our 3 schools are on there.
So I think what I hear you saying then, that there has been verification that whomever or parties involved actually have kids in those schools in our school district.
Yeah, I assume the judge is asked for an affidavit, that, you know, a sworn affidavit that says that if I'm a member of the plaintiff organization, I have a child at this school, and that's where it comes in.
Okay, again, I go back to an earlier statement I made regarding a previous report, and that is, I know we have a legal and a moral obligation to educate all kids. And I know on this agenda, we also have a upcoming report on safety. I consider this to be a safety issue for children who need to be supported emotionally and socially as well as physically, and who need to maximize their education in an environment that promotes safety, and that includes all kids to me.
Mhm.
And so I'm really concerned about, I believe in minority rights, but I also believe in the rights that we, and the obligations we have to educate all kids morally and legally. And so this whole issue concerns me, especially if it involves people who do not live in our school district and do not have children who attend here, any more than I would have a right to go to another neighboring school district and complain about their programs. I don't have that. I don't have an interest. I don't have children there. I live in this district, and so I'm confused by all this, these court challenges, because I think it puts our kids at risk.
And one of the things I always remind people in other districts too, you have a pupil non-discrimination policy.
Okay.
You have 2260, I'm guessing it's 2260, which speaks clearly right out of statutory, Wisconsin statute 11813.
Okay.
Talks about the different protected classes, you know, including students with disabilities, that are, you know, you cannot discriminate based on any of those criteria. And that would also include harassment as well.
Okay, thank you.
All right.
Thank you for that.
Dr. Hess, do you have anything?
All right. Stephanie was
Mrs.
first.
Carroll?
No,
Kelly had
no,
something.
no, go ahead.
You can go
I don't
first.
have anything.
I'm sorry.
So I think I've got a couple of questions and a few comments. I think on July 17th, I participated in the WASB legal update, and I think they told us that definitively no school system has ever lost funding because of a Title IX issue kind of thing. So I think that's the Wisconsin Association of School Boards telling us that. So I think last time I spoke and said I couldn't find any, but I can't say that I'm the definitive person in terms of looking up this kind of stuff, but if WASB says it, I kind of tend to believe it. I'm curious about, so there are these 8 federal cases, and I think all 8 of them ruled against the Title IX rules, against the Department of Education, issued injunctions. Then 2 cases went to circuit appeals, and both of those upheld the injunctions, correct?
Correct.
Is there not also, I thought there was something where the Department of Education has appealed directly to the Supreme Court to try to get a limit in terms of, they are saying, hey, there are elements of this that we want. Can you
Yeah,
tell us a little
that's
more
good
about
point,
that?
Yeah, so in other words, not every part of the final rules needed to be separated.
Right.
And interestingly, the Kansas judge took up that argument and rejected it, and then under the theory that that's something that the feds could have proposed, is they could have proposed, all right, if these, you know, severability clause, basically,
Mhm.
if these get challenged, the rest go forward. The feds did not put that in there, okay? So they didn't have that ability to sever various elements of the new final rules.
Good. And So I think in the Kansas case, the one that is impacting us, I think a number of them talked about the concept of how the law was made or whether that imposed financial issues on the states. And so there's kind of these meta issues. But this Kansas one specifically dealt with an individual child. And in part, that's why the injunction is applied to all these different organizations. But I think they said something to the extent of the personal involvement, the issue as to why it applied to individuals was a question of suppression of free speech. That they felt like, I think the judge said, something to the extent of, hey, I've asked all the attorneys in the room, can you tell me what advice I need to give to parents in terms of what is allowable speech in regards to some of these issues? And no one could say anything. And he said, well, if you could potentially get punished, but you can't tell a parent how to advise a kid, that's going to suppress free speech. So my question is, if we were to vote and adopt these rules, is that the risk that we face, that some member from Moms for Liberty, a plaintiff organization, comes forward and says, hey, I believe my child is suppressed in terms of free speech. Is that a type of ruling where we can say that's a risk for us, or?
I don't believe that the final rules would change that risk analysis. Again, using the Whitaker decision as the basis for that within the Seventh Circuit.
Okay. And my final question is in regards to, I think you had suggested that the injunction will now definitively apply to the 3 schools, and that somehow the judge determined it was good enough, so we're buying that argument. So what happens if a child who is in, I think we were at West and Carl Traeger Middle?
And Traeger Elementary.
And Traeger Elementary.
Those
Yeah.
3, yeah.
So what if a middle school child or a high school child is participating in a track meet over at North? Now, is there a mixture of rules here where the North kids get to go under the new, if we were to pass this, North kids go under the new Title IX, West kids are under the old Title IX because that school is enjoined? And does that create, is that a problem in terms of equal protections clauses, or?
It wouldn't be an issue under the Equal Protection Clause. It would just be more of a procedural aspect.
Okay.
You'd probably err on the side of granting the greater rights to the child based on the venue. So I think that would be how we would construe that. That would be an interesting situation. I'm not gonna lie to you, that would be a
You want to take that one
a
to the Supreme
difficult
Court?
one. Yeah.
What, is anyone else?
I'll have some questions too.
Oh.
Go for it, Chris.
So, within this litigation, 'cause I think it's good for the public to hear, if you could summarize it, what are the lawyers obstructing to in Title IX that they don't like, right? What rights in your summation are being violated? And what parts of the Title IX policy are these groups most opposed to?
Okay, so what they're most opposed to is the expanded definition of sex-based harassment. Okay, and their argument is that Title IX says the word sex, period, right? And if you look at the legislative history, when the educational amendments of 1972 were written, I believe it went into law in 1975, there was a pretty commonly understood definition of sex, male or female. And so to expand it to include harassment, okay, is an expansion of the word discrimination. And then secondly, and this is really the crux of the issue, defining sex-based harassment to include things other than discrimination or harassment based on male or female status. Okay, and Fortunately, my computer went dead, but I have, I can log in. I mean, they just have it, it's going to be based on, sex-based harassment can include gender identity, one's, trans sexual status, pregnancy-related conditions. Again, just essentially the sexual orientation. Okay. And I'll note, by the way, that Wisconsin law already protects students
Yeah.
based on sexual orientation. Okay, so there was, that was the crux of the issue. Secondly, the Department of Ed did not define the word sex, but they did define sex-based harassment, what examples of that, okay? So that was primarily an issue. One of the other primary issues, it always kind of boils down to bathrooms, right, at the end of the day, like, and so what the new rules would say that a student may use a restroom based on their gender identity, okay, and a school cannot make a child go through anything more than what's considered de minimis harm, in order to access those restrooms. Okay, so in other words, you can't make a child, submit a 20-page document, signed by, 8 doctors that says that they're allowed to use this restroom. That would be more than a de minimis harm, okay?
So these protections are already in state law, right? That's what you said.
Well, it says, it specifically says sexual orientation in Chapter 118.
Okay, so the protections are in state law, but the groups are opposed to the protections being put in federal law?
Correct. And on top of that, they're arguing that there's, religious liberties involved here under the First Amendment. Okay, so in other words, one of the arguments is that my religion identifies males and females, and to deviate from that would not be allowed me to.
Okay. Thanks. I was just trying to there's a lot of, anyone watching at home is probably like, what exactly is going on in here?
Yeah,
You know what I mean?
they're
'Cause
not
we're talking
objecting
about,
to the procedural nuances of the matter. They're objecting essentially to the Department of Ed's definition of this, okay? And I guess this was coming down the pike based on the Bostock decision that you may have been familiar with in 2020, which interpreted Title VII, which is employment discrimination law, which then said that discrimination based on gender identity falls under Title VII, and so that we kind of naturally anticipated that the Department of Ed would look to Title VII for guidance with Title IX, and that's pretty much what happened here.
thank you.
So I'm struggling with the question, what is best for students? Because every decision I make, I ask myself, what is best for students? And I don't see how us getting into this conversation is helping any students. I don't think I don't think the school board is the right place to have this kind of conversation. So I would like to see this go back to committee and come back to the board for a vote. Are you saying that we can't do that, or?
That was our plan, to bring
Yes.
this back to policy and governance.
Yeah. Okay, and then
at our
we're gonna-
September meeting to have continued conversation, and then have it go to the board in the future.
And then
for-
have it go to the board. And now that we have a new board member, we will not have a tie. So, okay.
And it's also, we can't ever re-vote on the same thing, so it was really good to have Sabrina and Attorney Kapocious with us this evening. And as things are changing, ever-changing, we have new information that they would have to come in a different way.
Can I ask, since we
Yes.
do have Attorney Kapocious with us, so we have our legal representation for the district here with us on this issue. You stated, and I think Tim also stated, that as far as you know, no school system has ever lost funding because of a Title IX issue. However, have the facts always been the same as they are now, where we would have to have a staff member assert that either we are in compliance with the current regulations as they apply to in the Seventh Circuit, or not? Has that fact pattern ever
I'm
happened?
not aware of any fact patterns similar to that one.
Okay. And So I think we do always have to worry about students first. And looking at, students are coming back to school within the next couple of weeks. If there is a gender identity discrimination case that comes up, which is based on sex-based harassment, that case occurs, we get a complaint. The district gets this complaint somehow through our Title IX coordinators. What are our gaps? What are our potential grounds for liability that we face as a district right now?
Well, I mentioned before, we're in the Seventh Circuit, right? So the district has a duty to follow up on complaints related to sex-based harassment.
Do our policies currently explicitly reflect the Whitaker decision and cover the same things in writing that are covered in the new Title IX regs? It's the same definition of gender identity, including pregnancy, including gender identity, and things like that.
Including
I don't-
those that are not in our current.
Nor do I believe that Neola recommended anything other than what's actually in the statute, which is.
Right, but it would recommend putting in the regs that.
Well, you'd follow the regs, right? I mean, you don't repeat all the different federal regulations, you just.
But if we don't have policies that actually do that, would we be open to liability if, say, we didn't handle it quite as it is required under the current regs in effect in Wisconsin?
Well, if you have the policy, Sabrina, I don't believe that it did get deep in the weeds on identifying the various characteristics of what's considered sex-based harassment. The policy, even revised, did not include that. Okay.
One other point of clarification that I wanted to make when you guys are asking about state law, and other decisions that Title IX or Title VII decisions, you said they've addressed sexual orientation. I think they're actually two different points. With the state law addresses protection for sexual orientation. Does it protect the same level gender identity as defined? If I'm understanding correctly, the Title VII issues do, but at the state level, we do not have those same requirements and expectations of us.
Yeah, so Chapter 18 would say the word specifically sexual orientation.
And that's not the same as gender identity, is it?
Probably not. Yeah, I don't believe there's been a court that has interpreted sexual orientation to mean anything other than what we would consider, yeah.
Okay.
I forgot to add that I think it's important to note that the action that's the organization that is driving this effort is labeled as an extremist group and a hate group. So I just think that should be said. That's it. Thank you.
Okay. Thank you very much for enlightening us this evening. I hope we are better educated than we were when we came in. As we mentioned, it will go back to policy committee and work through it there, and we'll see what happens with it at that point.
Yeah, thank you.
Thank you very, very much.
Thank you.
Okay.